dismiss and a motion to exclude the commission from considering second cousin as presumptive of conflict. We've had an opportunity to review those briefly. Mr. Mando, do you wish to respond?
With regard to the motion to exclude based upon the second cousin, as I understand, I only had briefly an opportunity to review that motion, but we submit that that's irrelevant to the disposition of this particular charge. The charge against Judge Allred is that he issued the grand jury order in retaliation for the affidavit that was filed that day by Mr. Grisham, or signed by Mr. Grisham, filed by Mr. Howard in the Potter v. Howard case, and in order to influence the election. The fact that it's a second cousin and that doesn't somehow fall within some statutory definition is irrelevant to the disposition of the charge and the nature of the charge against the judge.
Thank you. Judge Allred, do you want to be heard?
I just wanted to be clear that I don't want anybody on the commission to be confused that because the word cousin was used over and over again, that created some type of presumption that was an automatic conflict because this person was a second cousin. And I just simply referred you to the definition of third-degree relationship, which are automatic conflicts. I didn't want there to be any confusion from my standpoint or anyone else's standpoint about that. I was conceding that was an automatic conflict. I think at that point it goes on relationships as opposed to mandatory disqualifications.
Thank you, Judge. Mr. Mando, on the motion to dismiss, do you have anything to say?
Mr. Kelly's going to respond to that, please, Mr. Chairman.
Thank you.
Mr. Chairman, in the brief time I've had to read this motion, it seems that Judge Allred is pointing to, the basis for his motion to dismiss is Mr. Weaver's testimony yesterday that he had a meeting with Judge Grisham, in which the motion says that the testimony was recanted and because the report wasn't given, that this is grounds for dismissal. The testimony of Mr. Weaver was there was no recantation of the testimony, and in fact, when Judge Executive Grisham testified, other than saying, I recant, he really didn't provide a recantation in his testimony either. Mr. Weaver was testified, he explained that other than making these statements, what he phrased as bizarre statements about the sheriff and the Commonwealth Attorney, there was no recantation, that's why he didn't file a report. This violation didn't occur. The motion misconstrues not only Mr. Weaver's testimony, but talks about intentional withholding of evidence. There hasn't been. The commission has acknowledged out of the thousands of pages provided to Judge Allred, 24 pages were inadvertently not provided. The commission has dealt with those issues. That's not really, shouldn't be before the commission at this point. The only other thing he brings up is the fact that some witnesses were not interviewed. Again, Mr. Weaver testified to that. He said the witnesses that weren't interviewed related to allegations which had already been instructed by the commission that the commission were no longer pursuing. So I feel there's clearly been no due process violation, and I think the remaining counts should stand and be heard before the commission.
Judge Allred.
And brief response to that, I think Judge Grisham was unequivocal in his testimony that he had recanted, and I think that he was pretty straightforward that he felt that Mr. Weaver was attempting to influence his testimony. I think that's the way he had testified to it. Quite frankly, I don't know what context it would be okay for an investigator who's supposed to be a neutral investigator to tell a witness he's there, being paid to be there for, with the attorney from the Judicial Conduct Commission there with him, to make a statement that he would have an individual who was a complaining party or an adverse party to the judge apologize to him, and to say to him that another party who was adverse to the judge, a complaining party, in fact probably the largest complaining person in the entire issue, tell him that he was just trying to help him. I don't see what context that could possibly be okay for an investigator to do that. And quite frankly, I've never even heard of a situation where an investigator would make a statement like that to a witness. I think standard procedure in investigation for an investigator that I've dealt with over many years has been to simply interview a witness, write down what they say, follow up on their information, and report it. And I think that was the duty of the investigator for the Judicial Conduct Commission, was to report. And the thing that you miss in this is that the phrase pattern of conduct is used all the time against judges in judicial ethics situations. That's the big hammer. That's the big hammer to really go after a judge and point to all these things that happen over the course of time. If you look, and it's been my assertion throughout, there have been numerous things from the preliminary phases all the way through that have resulted in a cumulative effect of denying me due process. And I would just simply add to it, and I'll hush up, I'm not going to waste much more time, I know we're going to get this over with. But I would simply add to it that I have never been told where the 7-page summary is. I've never seen it. I don't even know if the commission's got it, and I still have never had an explanation as to why the 14 pages on an article of death is dismissed, but it's kind of just brushed over like it's inadvertently. What happened to it? Wouldn't you think that would be a good idea to figure out what happened to it? But in any event, my position is these weren't accidental things. It can't be accidental all the time. Just like when a judge has a series of things that happen, it's always argued that this is a pattern of conduct. And that's what I'm arguing here. This has been a pattern of conduct from this investigator from day one throughout this matter. There's some witnesses that weren't found, which was hard for me to believe that somebody on Main Street couldn't be located. It was a situation where, like on his testimony, I still can't believe that. I've been stunned all night with that. But anyway, that's my argument, and I thank you for your time this morning.
Thank you. We'll need to consider these. We will stand in recess, I would think, hopefully not long, but we'll take as long as we need. If you all just be available, we'll let the bailiff know when we're ready.
All right.